Hello, and thank you for downloading this podcast. This month, we are sharing the 2024 Case Law and Legislative Update Review that the Maples Group Irish Employment Team delivered earlier this month. This is an overview of cases and legislative developments from 2024, and we hope that employers in Ireland will find this helpful. Before we dive into today's subject, just some housekeeping to cover off. If you are listening in from your usual podcast app, you will find any resource documents and speaker information in the description. And if you've clicked on the media player link sent to you by email, then you can find this information in the notes section. So my name is Karen Killalea. I'm a partner and head of the employment team at Maples and Calder Ireland, the Maples Group's law firm in Dublin. I am delighted to be joined today by my colleagues, Kieran Lungig and Christopher Bew, who are both very hardworking associates on the employment team here at Maples. And we are highlighting some of the key cases and legal developments across the following themes, which we feel will be helpful for employers in Ireland. And those themes are performance management, managing absence, mandatory retirement ages, gender discrimination, dismissals, protected disclosures, settlement agreements, redundancies, and then we're going to touch on a couple of other key cases that we will mention, as well as some key legislative updates and codes of practice. So hopefully at the end of this webinar, you will have a good sense of the key developments in Irish employment law from 2024, as well as a sense of what is coming around the corner in 2025. Okay, this is also for those of you who hold practicing certs in Ireland as solicitors. This webinar will give you 75 minutes of CPD. So we're going to try to stick to the 75 minutes. I'm not going to promise we'll absolutely do that because there's quite a lot to get through, but let's get started. So Ciara, I'm going to turn to you first. Can you please talk us through a recent case on performance management?
Yes, absolutely. The first case we wanted to take a look at today is the recent WRC decision of JTI versus McGarry. While this decision is technically from late 2023, it is very helpful in terms of mapping out the key considerations to bear in mind when putting a performance management plan in place. So we hope listeners will allow us a little bit of discretion by including the case in our 2024 review today. So in this case, the employee was employed from 2008 until her resignation in September 2023. In 2021, the employee went on sick leave for over 5.5 months, and her medical certificates indicated that she was suffering from work-related stress during this time. In June 2021, the employee was deemed fit to return to work on a phased return basis, and the employee returned to full-time work in September 2021. The employee's performance review in 2021 was finalised in January of 2022 with an overall assessment by her manager of needs improvement. In April 2022, the employee was informed that she was being placed on a performance improvement plan for a period of 6 months. The performance improvement plan, or PIP, started in April, and in May 2022, following a PIP review meeting, the employee alleged that she suffered a panic attack and she was certified as unfit to work. The employee felt at this point that she had no option but to resign from her employment. The employee filed a claim with the WRC under the Unfair Dismissals Act, alleging that she had been constructively dismissed. In its decision, the WRC acknowledged that the employer was entitled to set performance objectives, but it was noted that the employer's performance appraisal processes, including the PIP, were provided for in the employee handbook. The WRC did not, however, consider that the employee's performance was managed appropriately, and it identified 3 flaws in how the employer had managed the poor performance. So firstly, it noted that the impact of the employee's illness had not been taken into consideration properly in determining next steps in respect of her performance. Secondly, the WRC noted that the employee's original performance objectives were not revisited on her return to work. And then finally, the WRC noted that the employee handbook provided for clear and open informal feedback throughout the year, and this had not been provided to the employee. So the employee was awarded €40,000 as compensation for unfair dismissal, the equivalent of 6 months remuneration.
Okay, interesting. So the policy was there, but I think it sounds like the WRC found that notwithstanding that, it hadn't been followed. So would you summarize perhaps a few key takeaways for employers from that case?
Yes, absolutely. Well, there are a number of key takeaway points. So I suppose firstly, employers should arrange regular performance feedback meetings to tackle potential issues as they come up and tackle them early. Without over engineering the performance reviews and discussions, the meetings and the feedback should, of course, be clearly documented. And employers should also be mindful that absence or illness may affect performance, and employers will need to take care that they're acting reasonably and assessing the employee on the work done, and not, in fact, penalising them for any deficiencies that are directly related to disability or absence.
Okay, that's great. Thanks very much for that, Ciara. All right. So, staying with that theme of managing absence, I'm actually going to talk momentarily about a case that we think is very interesting. In terms of what I would say is almost like a textbook example of how an employer can manage a disability or illness related absence. And this is the case of Roche versus Beacon Hospital. It's a WRC decision, so a decision of an adjudication officer, and the decision was published around April of 2024. So I'll just run through the factual pattern here. Again, as I say, I think it's a really good example of an employer managing with sort of patience and care and consideration a rather long medical leave related absence. So just to run through the facts, the employee in this case was employed from September 2016, and she took sick leave in July 2019 due to what she described as work-related stress. Ultimately, her employment was terminated by the employer due to capability issues in October of 2022. So she had been on sick leave for over 3 years. I think what's important to note about this case is the employer made extensive efforts to facilitate the employee's return to work. The HR director of the employer gave very detailed and compelling evidence at the hearing of the matter in relation to the efforts the employer had made to actually support a return to work. And as I say, I think it was quite exemplary the way they conducted themselves. The employer had made multiple attempts to contact the employee during her absence, and sometimes without a response. The employer had involved occupational health at a very early stage to get good, up-to-date guidance on how to support the employee. For example, the employee, I believe, was referred to Occ Health around sort of 4 to 6 weeks after she went on sick leave, and thereafter at fairly regular intervals. The director of HR met with her on several occasions. The process was extremely well documented contemporaneously. It was interesting to note that in the course of these conversations, the employee had complained about, relations with managers and colleagues, about work volumes, changes to the finance department in which she worked, and so forth. In response to that, the HR director had gone to speak to colleagues and had come back to the employee with an offer of a different role, but that was turned down. In the meantime, and over the course of the absence, certainly towards the end, the company doctor had recommended that the employee engage with the HR process and that she was fit to do so. As I'd mentioned, there were difficulties contacting the employee, but nonetheless, the employer was diligent in following up, sent emails, phoned, sent registered letters at appropriate intervals. Eventually, the employer, after about 2 years later, the employer notified the employee that they were considering terminating the employee on grounds of capability. So that was a full year before they actually did terminate her. They also gave the employee the option to submit her own medical reports in case she disagreed with the employer's assessment as to her capability. But in any event, by September 2022, there was difficulty engaging with the employee, and the employer communicated that they couldn't keep the employee's job open forever. They said they'd made good efforts to engage with her, and ultimately, then within a month or two of that, they did terminate by reason of capability. Now, the employee challenged the dismissal, but she didn't succeed. And the WRC referred to the well-established Labour Court principles in the case of Humphreys versus Westwood Fitness Club, sometimes referred to as the Westwood tests. And in short, it reminded us all, if you like, of the tests, which are what the employer has to do in a situation like this is make sure that they gather all of the material facts, including up-to-date medical evidence, before contemplating a capability-related dismissal. Secondly, the employee has to have fair notice of the proposal to dismiss, and the employee has to have an opportunity to participate in that decision-making process. So, as I said, not surprisingly, in my view, the WRC was satisfied that the employer had reasonably come to the conclusion that the employee did not have the capacity to perform the role, and they had taken all reasonable steps in order to assess that. So I think the key takeaways for employers in Ireland from this case are: absences due to illness do need to be managed patiently and sensitively and meaningfully. It's very important to get up-to-date medical guidance from your OC Health. Focus on the return to work rather than necessarily the absence and the illness, and be sure to document your efforts as an employer to do so. Finally, I think it's just interesting to note that the WRC decided that employers don't actually need to have a medical certificate in front of them explicitly stating that there's no prospect of return before they can effect a dismissal for capability reasons. Okay, Chris, turning to you, let's look at a recent Supreme Court decision on mandatory retirement ages.
Yes, so this is the case of Mallon and Minister of Justice from May of this year. So the background to this case is that under Section 34 of the Employment Equality Act, mandatory retirement ages are permissible if justified by a legitimate aim and proportionate means. So in this case, the employee, who was a revenue sheriff, challenged the mandatory retirement age of 70 after the Minister for Justice refused to amend it. So initially, in this case, the High Court upheld the retirement age, citing legitimate aims such as workforce planning, age balance, dignity, intergenerational fairness, and standardization across the workforce. So the employee then appealed to the Supreme Court, arguing incompatibility with EU law, improper assessment criteria, and lack of individual assessment. The Supreme Court upheld the decision of the High Court that the mandatory retirement age of 70 was justified and effective in achieving intergenerational fairness. The Supreme Court agreed with the High Court's finding that the use of a mandatory retirement age avoided difficulties within the workforce occasioned by health and capacity issues. It also decided that a retirement age of 70 across the public service and state agencies is not disproportionate and it meets a legitimate objective. That an individual capacity assessment should be avoided by employers because of its potential impact on the dignity of an employee. It also examined whether any financial hardship would arise from enforcing the mandatory retirement age, and it found that it did not cause any such financial hardship in this case because the sheriff was able to continue practicing as a solicitor.
Okay, that's great. Very interesting. Could you just talk us through maybe 2 or 3 key learning points from that Supreme Court decision?
Sure. First, employers should justify mandatory retirement ages with legitimate aims such as workforce planning, age balance, dignity, intergenerational fairness, and standardization across the workforce. Second, retirement ages must be proportionate and necessary to achieve these aims. As such, employers should ensure the retirement age is reasonable and not excessively low. Third, and finally, policies on retirement ages should be applied consistently and systematically, but employers should remain flexible and open to reviewing and adjusting retirement policies in response to demographic and workforce changes.
That's great. Thanks very much, Chris. I just mention as well that in our Maples Group Irish Employment Law podcast, we did an even deeper dive into the Mallon case, and we also looked at some other case law. So if any listeners are interested, particularly in that theme, you can access the podcast link, which will be in the resource materials. I'm going to say we did that probably about a month or 2 ago. There is also a code of practice on longer working, which is an extremely helpful resource. It's a government publication published by the WRC, and that will be in our resource materials as well. Okay, so thanks again for that, Chris. Ciara, turning to you, you're going to talk us through a decision, McGann versus ERS Genomics Limited, and this relates to gender discrimination.
Yes, exactly. And I think firstly, it's helpful to have a closer look at the background to this claim. So the employee in this case was the only female employee, and she was the excuse me, the only woman attending board meetings at the time. She was also a part-time employee. So in the course of her employment, the employee performed well in her role. She received excellent performance reviews and was promoted to head of finance in 2020. Her hours increased to 30 hours per week in January 2020, and she actually transitioned to a full-time role with effect from January 2021. The employee discovered, however, in 2021 that her salary increase for that year was significantly lower than that of her male colleagues. The male colleagues' salaries increases for that year had ranged from 12% to 50%, compared to her salary increase of 5.6%. The employee raised concerns with the CEO in respect to this matter, and the employer responded by engaging an external HR company to benchmark her compensation, and she was in fact awarded a salary increase. In May 2022, the employee requested to revert to part-time work and asked for a part-time accounts assistant to support her. And the employee was initially told that this might work. However, the employee's part-time work request was subsequently declined. The employee actually alleged that, by contrast, a male colleague's part-time work request was granted around the same time. So in November 2022, the employee was advised that the employer was creating a new vice president of finance role. The employee alleged that she was advised by the CEO to start looking for a job. She didn't raise any grievances until the 3rd of January 2023, when the employee's solicitor sent a formal grievance letter to the employer. The employee resigned on the 16th of January 2023, just 10 days after filing her grievance through her solicitors, citing her dissatisfaction with the response from the employer. And the employee then filed claims with the WRC under the Employment Equality Acts. The employee alleged in her claims that she had been subject to a discriminatory constructive dismissal, gender discrimination, and victimization. Interestingly, the WRC did not uphold the employee's claim for constructive discriminatory dismissal. The WRC found that the employee had actually resigned without giving the employer a reasonable opportunity to address her grievances. And the AO noted that the delay in responding to the employee's grievance letter was not excessive given the circumstances and given the time of year. Finally, the WRC did not uphold the employee's claim in respect of gender discrimination or victimization. The WRC found that the facts relied upon by the employee did not support the inference of gender discrimination in this case.
Okay, a lot to take in. Can you perhaps summarize 2 or 3 key takeaways for employers in Ireland from that case?
Yeah, absolutely. I think the case highlights the importance of avoiding discriminatory practices and ensuring that decisions regarding pay, promotions, and work arrangements are based on objective criteria and that they're free from gender bias. Managers should, of course, receive regular training on recognising and preventing discrimination in the workplace. And I suppose finally, employee grievances should be addressed promptly and in accordance with established procedures, even where the employer may be sceptical about the actual merits of the complaint.
Indeed, and as you mentioned, 10 days between sort of putting in the grievance and resigning was a little unusual. It was quite fast, so perhaps not an entirely surprising decision. Okay, thanks very much for that. Let's jump to the next case, and you're going to talk to us about Electricity Supply Board and Sharkey, which is a case that analyses issues of a workplace investigation, a parallel police investigation, and the right to silence. A very interesting case, and I think we all welcomed this decision when we read it.
Definitely, and I suppose to give a bit of background in terms of this case, the employee in this case had worked as a network technician for the employer, which, as you mentioned, was an electricity supplier in Ireland since February 2017. And in May 2022, the employer received allegations from 2 property developers that certain employees were demanding cash payments to speed up the completion of electrical metering works. The allegations were shared with the Irish Police Force on Garda Síochána on the 1st of June 2022, and the Gardaí conducted searches at the employee's home and vehicle, and he was advised that he was under investigation for bribery and corruption related to his work. The employer wrote to the employee requesting that he confirm if he had ever asked for or received any payments from third parties in connection with his duties with the employer. And the employee responded via his solicitor denying any wrongdoing and invoking his right to silence due to the ongoing criminal investigation. The employer filed proceedings with the High Court seeking a declaration that the employee's refusal to answer amounted to a breach of his contract, or in the alternative, an order compelling him to disclose the requested information. And the High Court was therefore asked to determine whether the employee's right to silence and privilege against self-incrimination permitted him to lawfully refuse to comply with the request. So what was decided and why? Ultimately, the High Court held that the employee's right to silence and/or privilege against self-incrimination permitted him to lawfully refuse to comply with the directions issued to him by his employer. The court noted that the employee was acting on legal advice in refusing to answer the questions, and the court explored the concept of the right to silence and the right to privilege against self-incrimination in Irish law. And it was acknowledged by the court that the right to silence has long been recognised in common law, but it has also been elevated to a constitutional status. Mr. Justice Mulcahy observed that a right to fair procedures may entitle employees to delay engaging with a disciplinary procedure rather than risking incriminating themselves when there are pending criminal proceedings. So the court noted that this reflects the court's recognition that the right to silence is a constitutional right engaged where there is that risk that a person may be compelled to provide testimony which may tend to incriminate them.
Okay, thanks very much for that, Ciara. Very interesting case. Complex. These are complex issues, and we do come across them in practice where you have something that is the subject matter of an internal workplace investigation and/or a disciplinary process, but because of the seriousness of it, it also has become a criminal justice matter. So I guess the key takeaways really are, number one, it may be necessary to pause an internal workplace investigation and/or a disciplinary process where relevant information is not available to an employer until a related criminal investigation has actually concluded. And I think unless it is very clear that the employer's interest in securing the information from the employee outweighs the risk of an infringement of that, as you said, sort of common law, constitutional right to silence, then the right to silence will prevail. So look, thanks very much for highlighting that case. Chris, I'm going to turn to you. Protected disclosures. Now, unlike in previous years, we haven't had a huge amount of case law this year, but nonetheless, you've dug out a useful case for employers in Ireland, if you want to talk through that.
Yes, indeed, Karen. So in the case of O'Toole and the Department of Agriculture, Food and the Marine, this employee alleged penalisation after making protected disclosures under the Protected Disclosures Act. So just to recap on that, the Protected Disclosures Act concerns workers making disclosures of relevant wrongdoings in the workplace which attract certain protection. So this act prevents the person who is making the protected disclosure from penalisation in response to having made that protected disclosure. So in this case, the employee claimed that he made disclosures in February and June of 2022 regarding fraudulent overtime payments, incorrect rates being charged for fishing vessels, and the unlawful selling of scrap metal. He then claimed that in response to having made these protected disclosures, and for the first time, he was asked to pay harbour fees for his private vessel with the threat of legal proceedings if he didn't pay. And as such, he was treated differently to his colleagues. The WRC in this case were asked to decide whether the employee had made a protected disclosure, and if so, whether the employer had penalised the employee in retaliation for having made that protected disclosure. So ultimately, the WRC decided that the employee had made a protected disclosure in June of 2022 when he had communicated his concerns to the chief engineer of fraudulent overtime payments, amongst other concerns, and that the employee had been penalised by the employer in retaliation for having made this protected disclosure. The employer contended that its request to the employee to pay the harbour fees was made purely for operational reasons, based on a legitimate review of harbour operations, and was not influenced by any disclosures made by the employee. Ultimately, however, the employer's argument was not accepted by the WRC, and it found that this was in fact penalisation. In the WRC arriving at this decision, it was notable that none of the employee's colleagues were asked to pay these fees, and the employee was only asked to pay the fees for the first time following the making of his protected disclosure. The WRC determined, using the but-for test, that had the employee not made the protected disclosure, the employee would not have been asked to pay the fees. Consequently, the WRC ordered the employer to pay the employee 25,000 euros in compensation for penalising the employee for having made a protected disclosure. So, in terms of the key learning points for employers from this case, first, it is important to note that a protected disclosure does not need to be explicitly labelled as one by the employee. Any complaint or issue raised should be assessed by the employer to determine if it qualifies as a protected disclosure. Second, employers should investigate protected disclosures promptly using the protected disclosure policy. Third, this case illustrates in particular that the types of detriment which the WRC might consider to be penalisation in response to an employee making a protected disclosure are clearly extremely wide.
That's great, Chris. Thanks for that. The factual backdrop is very interesting in that case. And as you say, it just illustrates how what can constitute something perhaps as innocuous as a legitimate request for harbour fees can constitute penalisation. So thanks for that. All right, you're going to talk to us briefly about another case on settlement agreements.
That's right. So this case was one of Flanagan and Ulster Bank, and involved an employee filing claims under the Unfair Dismissals Act, the Protected Disclosures Act, and the Central Bank Supervision and Enforcement Act of 2013. So the employer argued that prior to filing these claims, the parties had in fact already entered into a settlement agreement under which, in exchange for the waiver of all the employee's claims, the employee was paid an ex gratia payment of 145,000 euros. The employer argued that the claims should not be heard by the WRC because a valid release and waiver had been entered into by both parties. The employee argued that he had not taken legal advice and the agreement was not valid and binding. In terms of what was decided here and why, the WRC found in favour of the employer. It held that the settlement agreement was validly entered into, considering the employee's experience and qualifications. Before entering into the settlement agreement, the employer had not explicitly advised the employee to seek legal advice. However, in this case, the WRC noted that there was a paragraph within the agreement where the employee acknowledged that he had been given an opportunity to take advice as he considered appropriate. The WRC also seemed persuaded by the employee's qualifications and experience and accepted that the employee was a capable and competent person who knew what he was doing. The employee had also described himself as a prudent man in cross-examination during the hearing and had confirmed that he understood what key terms within the settlement agreement meant. The employee had been given 4 weeks to consider the agreement and always had the option to refuse the agreement and accept statutory redundancy instead. In light of this, the WRC decided that the employee could not now complain that he did not understand the terms of what he had agreed to. So the key learning point for employers from this case is as follows. The employer should advise employees to obtain legal advice before entering settlement agreements to ensure validity. Not doing so will create a vulnerability which could be exploited by an employee who later makes a claim. Otherwise, there is always a risk that the employer will have to relitigate the matter.
Yeah, I would definitely echo that. While that case certainly does seem to give a nod towards somebody being compelled to comply with the settlement agreement where they haven't actually taken independent legal advice, obviously it's better to just close that loop off completely. So our recommendation would always be that the employee does take that independent legal advice so they're fully informed when they enter into a settlement agreement, and that makes it much more fair and equitable and valid. Okay, thank you very much for that, Chris. So Ciara, turning back to you, we are going to switch gears here a little bit, and we're actually going to look at 3 different cases on the subject of redundancy. And the first is the Labour Court decision in Crowe versus Debenhams Retail Ireland Limited and others. This dates back to April of this year. And there was some very helpful analysis in this case around consultation, when it should start, and what constitutes proper redundancy consultation. So, Ciara, do you want to take us through these cases, starting with the Debenhams case?
Yes, certainly. And no doubt many of our listeners will be aware of this decision. But just by way of background, on the 8th of April in 2020, the parent company of Debenhams informed the Irish subsidiary that it could no longer provide funding. There was quite a long and complex history to this case, but by way of very brief summary, the board of Debenhams Retail Ireland Limited held an emergency meeting at that point in time and recommended to their shareholder to take immediate steps to petition the High Court to wind up the company and appoint a liquidator. The liquidators subsequently wrote to the employees, providing them with notice of termination of employment. So in respect of this particular case, the claimant had worked in Debenhams for over 20 years. There was a large number of employees who brought claims before the WRC, and they submitted that the consultation and information obligations set out under sections 9 and 10 of the Protection of Employment Act 1977 had not been complied with. The employees alleged that the employer had failed to commence the consultation as early as it should have to allow for meaningful consultation in good time, and that the employer had not complied with its obligations to provide relevant information in relation to the proposed redundancies. So in terms of what was decided, the Labour Court noted that the key issues for consideration were: when did the consultation commence? Did the consultation start in good time or at the earliest opportunity, as is required under legislation? And when should the consultation have commenced? And in terms of whether the consultation process started in good time, as required by the legislation, it was noted that on the morning of the 9th of April 2020, the board of the employer entity met and resolved that the employer could not keep trading as a going concern, and that the employer should cease trading from all stores with immediate effect, and that they should issue a letter to the sole shareholder requesting that they petition the High Court to wind up the employer entity. It also found that given that Debenhams Ireland had asked the sole shareholder to petition the High Court to wind up the employer entity, this suggested that a commercial decision had been made at that time, which compelled it to plan for collective redundancies. The Labour Court noted that there was a gap in time between the decision to write to the sole shareholder and proceeding to the High Court, and it was noted that in order for there to be any possibility of reaching agreement with the employees, consultation should have commenced at that point in time, where it became clear that collective redundancies were going to be a feature of this process. The employer therefore did not commence consultations early enough to allow for meaningful consultation in this case, and the consultation process should have started on the 9th of April 2020, when the decision to cease trading was made, and at which point it was clear that redundancies would have been contemplated. In terms of key takeaway points for employers, this decision definitely confirms the strict legislative obligations that an employer is under when a collective redundancy situation arises. This case also makes it very clear that the obligation to commence consultations is triggered early and may even be invoked at the point when collective redundancies are first being contemplated. An employer does not have to be certain that collective redundancies will definitely arise. The obligation may be triggered where a decision could result in collective redundancies arising. Also worth noting just at this point that the Employment Collective Redundancies and Miscellaneous Provisions and Companies Amendment Act 2024, a little bit of a mouthful, was signed into law in May 2024, so earlier this year, and the Act widens the scope of the consultation obligations to provide that responsible persons will have an obligation to consult with employees. And for the purposes of the legislation, responsible persons will include liquidators, provisional liquidators, and receivers.
That's great. Thanks very much, Ciara. And yeah, I mean, certainly in practice, we would see it quite a lot that employers sometimes will just leave it a little bit late, or perhaps seek to truncate the consultation. And obviously, given the very significant penalties under the relevant Irish redundancy legislation, that is not advisable. So a very helpful decision in terms of focusing the mind on the meaning of consultation, and that it is very important to start it at the appropriate time, as soon as you say redundancies are being contemplated or planned for. Okay, so the next case that you're going to take us through is the case of Rooney and Twitter. And this analysed a slightly unconventional approach by an employer to effecting a restructure and redundancy. So will you tell us what happened in this case?
Yes, a really interesting decision, which was published in August of this year. So in this case, the employee submitted two claims to the WRC, a claim for unfair dismissal under the Unfair Dismissals Act and a claim pursuant to the Payment of Wages Act. The employee in question commenced their employment with Twitter in September 2013. And on 16th of November 2022, Elon Musk, the new owner of Twitter, sent an email to all employees, including the employee, outlining the future direction of the company. The email emphasized the need for extremely hardcore work, long hours, and high intensity. And employees were asked to click yes on a link if they wanted to stay with the company. The employees were advised that those who did not respond by 5 p.m. Eastern time that day would be dismissed and would receive 3 months severance pay. The employee in question did not click yes by the required deadline, as he felt the information provided was insufficient and the timeframe was too short for him to make an informed decision. The employee's access to the company's system was deactivated on the 18th of November. And at the time of his purported resignation, the employee's total compensation package was approximately €360,000, including basic salary of €137,000 plus a 30% bonus, a performance-based bonus. So in terms of what was decided, the WRC examined the definition of resignation and found that the employee had not resigned in this case. The WRC found that the purported acceptance of what was wrongly characterised as his resignation was in fact and in law a dismissal. The WRC noted that the dismissal in this case enjoyed the presumption of unfairness, and in the absence of any substantial grounds justifying the dismissal, the presumption of unfairness was not rebutted. In terms of the quantum of compensation to be awarded to the employee, it was submitted that by the employer at hearing that the employee had contributed 100% to his loss. And the WRC on that point highlighted that the question to be considered was whether the employee had actually done anything wrong by not clicking yes. And it was found that the employee was not guilty of a breach of his contract or insubordination. The WRC noted that the choices which the employee had been faced with were, to quote from the judgment, vaguely and incompletely set out and required further information, time, and the procurement of properly informed legal advice. The employee was awarded €550,131, which is a record-breaking award. In terms of key takeaway points for employers, the decision highlights to employers the importance of clear communication and adequate notice. It's interesting in this case that the WRC highlighted that the employee had not been given adequate time. The employee had received 24 hours notice, and that is just the decision would have required legal advice. The decision also highlights the importance of a resignation being clear and unequivocal. The failure to click yes in response to an email was not considered to be a valid resignation in this case.
Okay, that's great. And then the spectre of getting independent legal advice raising its head again. Okay, final case on redundancy that you have identified, and this concerns selection criteria.
Yes, in the case of Grania Sherlock versus Pluralsight Ireland Limited. In this case, the employer announced a global restructuring of its workforce due to company performance and economic uncertainty. And on the 12th of December 2022, the employee was advised that her role was at risk of redundancy. The selection criteria utilised in this case was based on a combination of past performance, which was weighted 20%, and a competency-based interview, which was weighted 80%. And the employee claimed that this selection criteria was unfair. She alleged that the process had been predetermined and lacked procedural fairness, and she argued that the selection criteria was manipulated to ensure her redundancy, and that the interview process was actually biased and lacked transparency. In terms of what was decided, the WRC concluded that the redundancy process did lack transparency and fairness, in particular by reference to the selection criteria. It determined that the redundancy selection process was not sufficiently objective and was in fact biased. The employee was not adequately informed of the criteria beyond the selection process, and further, the employer was unable to prove that the employee received fair treatment and received an objective assessment in comparison to her colleagues. The employee was awarded €122,000 in the form of compensation for financial loss due to her unfair dismissal. And then I suppose to turn to key takeaway points for employers, it's crucial that selection criteria for redundancy needs to be fair, objective, and consistently applied. And this comes up for us quite a bit in practice. It's very important that the selection criteria utilised is objective. In this case, the selection process involved a competency-based interview and past performance, and the WRC found that this process was neither fair nor objective to the employee. There needs to be an effective consultation exercise carried out with the at-risk employee, of course. And in this case, the WRC held that the consultation process was inadequate, as it seemed to be more about reinforcing the selection process and reviewing internal opportunities rather than genuinely consulting with the employee about the redundancy situation or the selection method. And finally, employers should consider and respond to employees' requests during the consultation process, such as requests for extensions or additional information. And again, that tends to come up in practice quite a bit. And an employee might ask for a short extension during the consultation process to deal with some outstanding queries. And in this case, the employee had requested an extension to the consultation process, which was not responded to by the employer. And that was noted to contribute to the finding that the employee's dismissal had actually been unfair.
Okay, that's great, Claire. There are three really excellent decisions from 2024, which will help to sort of shape and inform, hopefully, listeners' planning for restructures and redundancies should you need to do so. Okay, I am now going to mention briefly two significant cases from earlier this year, two High Court decisions. And both of these decisions probably deserve more time than we have available in the context of this webinar, which is sort of an overview of 2024. But I do want to flag them for listeners. They will be in the resource materials, and I'll just signpost that we will actually do a deeper dive into both of them in our next season of the Maples Group Irish Employment Law podcasts. Okay, so the first case that I want to touch on is the decision of the High Court in Craigana Limited versus Cullen and Lake Regional Medical. And this case relates to the enforcement of a 12-month non-compete clause in a contract of employment. So in this case, the employee occupied a very senior and specialized role with access to highly confidential information relating both to his employer and to customers. So that's a key point. So he resigned in January of 2024, and he was about to take up a role with a direct competitor. And the evidence before the court on affidavit was that the employee in question was leading a series of very sensitive, confidential strategic projects for his existing employer, and that gave him access to highly confidential, as I say, employer and customer information, including in relation to product and pricing and strategy. And there was absolutely no suggestion in this case whatsoever that the employee was guilty of any wrongdoing. He wasn't trying to take customer lists or confidential information. That seems quite clear. I think all parties were satisfied that that was the case. That's not always the case in these situations, but it was definitely the case in this one. So also interesting to note and relevant that this employee had been promoted a number of times. So he'd taken up a couple of different roles, had quite different responsibilities by the time he left compared to when he joined and entered into the contract of employment and signed up to the restrictive covenants. So the former employer, the old employer, if you like, sought an interlocutory injunction restraining the employee from taking up the new role, and they wanted to enforce the 12-month non-compete. And in essence, their argument was that without the enforcement of the non-compete, it would be pretty much impossible to police the protection of the confidential information which the employee had access to. And in practice, they said, look, we're not accusing him of any wrongdoing here, but in practice, it's going to be impossible for him to do the role for the new employer and deliver the value that they're paying him for if he doesn't at some level deploy this confidential information. So the old employer also argued that it needed to protect its customer connections. And it also said, look, we're going to continue paying this individual pending the full trial of the action, which was going to happen about 4 months later. So I think this was around February, March time. And it was agreed that the full trial of this would happen about 4 months later in or around July. So in short, the old employer said, look, we need to be able to rely on this 12-month non-compete. The balance of justice lies with us getting the order. The employee is being paid. He's not at a loss. Now, the employee and the new employer, the competitor, argued obviously to the contrary, and they said, look, the non-compete clause, it's 12 months, it's invalid, it's overly broad, the geographic scope is way too wide, It was put in place 8 years ago. It's no longer valid. The employee has changed role, and really the validity of this, if you like, the reasonableness and proportionality, and therefore the validity of this non-compete needs to be assessed by reference to the role he had at the time he signed up to the restrictive covenant. They also argued that the balance of justice lay with the employee not being forced to comply with the non-compete, because that would mean that he would lose the opportunity to work for the new employer. So, compelling arguments on both sides, but ultimately Mr. Justice Oisin Quinn in the High Court was persuaded that the old employer had shown that there was a serious issue to be tried on the basis of the above facts. And he noted that there are numerous examples from the case law that a 12-month non-compete for a senior employee can be considered proportionate and justified. And that's particularly where that non-compete is required to protect confidential information. And he referred in particular to the Ryanair and Bellew case, which is a High Court decision from 2019. So finally, in granting the order, enforcing the 12-month non-compete and restraining the employee from going to his new role, he assessed the risk of injustice to the employee in terms of him losing that new role. And Mr. Justice Quinn concluded that he wasn't convinced on the affidavit evidence before him that injustice would in fact arise for the employee. And in any event, he was going to be paid pending the trial of the action and wouldn't have a loss. So it's a very interesting decision. And Mr. Justice Quinn had plenty more to say about restrictive covenants. As I mentioned, we will give this case the full attention it deserves when we have a little more time, and we'll do that in one of our next season podcasts. Okay, the second case that we really have to mention, because it received quite a lot of media coverage, is the case of Nolan versus Science Foundation Ireland. Again, this is another decision of the High Court. The matter is under appeal as we understand it, so we're just going to talk a little bit about the significance of this case. So by way of background, in this case, as listeners may know, the employee was a very high-profile individual, and his employer had conducted and in fact concluded an investigation using an external barrister, an expert in employment law, who had focused on allegations of bullying and poor corporate governance. He'd concluded that investigation, and arising out of that investigation, the employer decided to conduct a disciplinary process in relation to the employee. So no finding of bullying or wrongdoing had been made against the employee, and the employee categorically and strongly denied any wrongdoing. Nonetheless, the employer decided to commence a disciplinary process into certain matters that arose from the investigator's report, and that was communicated to the employee. Now, shortly after all of this transpired, the board of the employer notified the employee that the employment was being terminated in accordance with the contract of employment. No allegation of misconduct was made in connection with the termination of employment. And in practice, really what was happening here was the board had, or at least had attempted to effect what is sort of sometimes described as a, in inverted commas, no fault dismissal. Now, the employee challenged this, and he sought and in fact obtained an interim injunction from the High Court restraining the employer from taking any further steps in respect of his dismissal, and various other orders as well. So he got those orders on an interim basis, and he, in essence, he had argued that he really was dismissed for misconduct, and that the dismissal entirely lacked the fair procedures that he was entitled to. The employer, by contrast, took a very different view, and they said, well, you were not dismissed for misconduct. This was a no-fault dismissal, and we're entitled to do it. We're entitled to terminate the contract at any time, for any reason or no reason or good reason or bad reason. We're just entitled to do it as a matter of contract, provided we give you the notice and we terminate in accordance with the contract. And they further said, look, the fact that there has been an investigation and the fact that it may or may not have been communicated to you regarding a disciplinary process did not affect or erode its contractual power to terminate the contract in the manner that it did. So as I mentioned, the employee did get interim orders. There was then an interlocutory hearing of the matter to determine whether those orders would continue pending the full trial of the matter. And in summary, the court was not satisfied that the employee had established a strong case that he had been dismissed on grounds of misconduct, and it refused to continue the orders that he had obtained on the interim at the interim hearing. So the court noted that the notice of termination that was issued to the employee was perhaps a little bit ambiguous, but the court was very persuaded by the clarity of the affidavits that were sworn by various deponents of the employer, indicating that the board had categorically not terminated the employee for misconduct. So in the circumstances, the High Court decided that those orders restraining the termination should not be continued. So we do understand, as I mentioned, that this has been appealed to the Court of Appeal, so we'll watch this space in relation to any updates. Okay, we're going to pivot slightly here, and we're going to look at legislative updates and various codes of practice that we very briefly want to touch on and just flag for listeners. So Chris, you are going to talk to us first about the code of practice for employers and employees regarding the right to request flexible and remote working.
So this code of practice was finally published by the WRC in March of this year, which was issued pursuant to the Work-Life Balance and Miscellaneous Provisions Act of 2023. The code provides guidance to employees and employers with respect to requests for flexible and remote working arrangements. It is important to note that the code does not give a legal right to flexible or remote working. Along with setting time limits for employee request and employee response, the code sets out that an employer needs to consider the following when a request for remote or flexible working is received. So 1, the needs of the business, and 2, the employee's needs, i.e. the employee's reasons for making the flexible or remote working request. The code of practice prevents an employer from penalising an employee for making a request.
Perfect. Thanks for that, Chris. And actually, we have had the first recorded decision of the WRC on the code of practice recently, the TikTok decision. Do you want to run through that?
Of course. Yeah, that's right. So that was the recent Caribco and TikTok decision. So in this case, the employee argued that her employer failed to properly consider her request for remote working in accordance with the Work-Life Balance and Miscellaneous Provisions Act and the Code of Practice. The employee asserted that her employer focused solely on its business needs, disregarding her personal circumstances and reasons for the request. The employer's response was that it had carefully considered the request in line with the Act, which required them to objectively evaluate both their own needs and the employee's needs. After much deliberation by the employer, the request was denied, and the employee was informed in writing within the required timeframe, along with the reasons for refusal. Ultimately, the WRC found that the employer followed the proper procedures outlined in the Act and the associated code of practice, and that the employee's complaint was not well-founded.
That's great. Thanks, Chris. And actually, just in the past few days, a second case has also been reported. Similar outcome for the employer. The case is Raphael and Centric Health, and we'll have a copy of that decision also in the resource materials. But again, a situation where the employer was able to defend its compliance with the process and that it had correctly assessed the request to remote work, and therefore the employee's complaint that he was unable to continue exclusively remote working was found to be not well founded. So that's two cases that we now have, which is very helpful. In any event, arising out of that, what are the key learning points for employers then that we can share with listeners?
So the key learning points from this case are that employers need to first ensure all remote working requests are thoroughly reviewed, balancing both the employee's personal circumstances and the business needs. Second, keep detailed records of discussions, decisions, and the rationale behind accepting or rejecting remote work requests. And third, clearly communicate the decision and reasons for refusal in writing within the legally required timeframe.
Thanks very much for that, Chris. Okay, Ciara, you are going to talk to us about some legislative developments. Tell us about the Employment Permits Act 2024.
Yes, so the long-awaited Employment Permits Act 2024 was commenced on the 2nd of September earlier this year and introduced significant and welcome reforms to the Irish employment permit system, aiming to make it more flexible and aligned with the current needs of the labour market. So to talk through just a number of the significant changes, there is now a change, a new provision allowing certain employment permit holders to change their permit employer to another employer after a period of 9 months has passed since commencing their first employment permit in the state. And this is subject to the employee having at least 2 months left on their current permit at the time of application, which is very much a welcome development as this does come up for us quite a bit in practice. Another change that has been introduced, there is a new provision which allows for promotion and internal transfer in the same company where a permit holder would use the same skills and the employment remains eligible. So this removes the requirement for a permit holder to undergo a full and new employment permit application process each time they've been granted a promotion. And then one other change to note, in relation to the existing labour market means test, the requirement to place adverts for vacancies in print media has now been removed, and the 2024 Act provides for the publication of these adverts being placed on one or more online platforms. So moving with the times.
With the times, indeed. Okay, that's great. Thanks for that, Ciara. Chris, you're going to talk to us about some guidance that was published by the Health and Safety Authority in Ireland, and this is the guidance on managing the risk of work-related violence and aggression. Tell us about that.
That's right, Karen. So in June of this year, the HSA issued the guidance on managing the risk of work-related violence and aggression. So the purpose of this guidance from the HSA is to provide information and guidance to both employees and employers in all sectors on managing the risks associated with work-related violence and aggression. So this guidance includes information on both employers and employees' duties in relation to the relevant Safety, Health and Welfare at Work Act of 2005 and how employers can ensure adequate safeguards are put in place.
Okay, that's great. Thanks, Chris. And again, that will be put in with the resource materials for listeners. I am going to touch very briefly on revenue guidelines, which were published this year, and those are guidelines for determining employment status for taxation purposes. And this is of relevance to listeners who may work in businesses where independent contractors are used in order to plug resource gaps or perhaps on a more enduring basis. So we would certainly recommend that you take a look at the revenue guidance. So this guidance really helps businesses to assess whether a worker is engaged as an independent contractor or whether they are an employee. And it, if you like, it sort of explains and expands on the 5 tests which were established arising out of the Supreme Court decision in Revenue Commissioners versus Carson Midlands trading as Domino's Pizza. So according to the guidelines, the first of those 3 tests should be viewed as a filter, meaning that all 3 of those tests must be answered in the affirmative. And if this requirement is satisfied, then questions 4 and 5 will be considered to determine if an employment contract exists in the circumstances. So we would certainly recommend that you take a look at that guidance. We have also produced an update on the Carshan decision together with the guidance in collaboration with the Maples Group Irish tax team. So would encourage any listeners who are interested in digging a little bit deeper into that to take a look at those resources which are on the Maples Group website. I also want to touch briefly on auto-enrollment. It's on its way next year, and the auto-enrollment scheme, or as it is being labelled, My Future Fund, is a new voluntary opt-out basis retirement savings system for employees in Ireland. So we've never had auto-enrollment in Ireland before. It's a big step. It was the legislation underpinning this was passed into law in July of this year. And the new scheme, the new auto-enrollment scheme, is going to apply to employees earning more than €20,000 per year who are aged between 23 and 60 and who are not already contributing to a qualifying scheme. Once it starts, the AE scheme is going to provide for gradually increasing rates of contributions to the scheme. to the retirement fund by employees and employers from approximately 1.5% to 6% over a 10-year period. So the very latest on this is that a commencement order has now been signed into law, and the scheme is expected to go live on 30th of September 2025. Okay, so that wraps up our whistle-stop tour of case law and legislative developments from 2024. We've also given a brief glimpse around the corner as to what is coming in 2025. I've already highlighted that we will dive a little deeper into some of these themes in the next season of our Maples Group Irish Employment Law podcast, which you'll find on all the usual platforms. So I just want to say thank you very much to Ciara and Chris for that really clear and helpful explanation of all of those cases and the helpful summaries of the takeaway points for employers in Ireland. A number of questions have been sent into us by listeners, and I thought that I might just go through some of those now. So the first question that I see here is, we are seeing an increase in medical certs being produced to facilitate remote working for extended periods of time, where we would expect 3 days in office attendance. The employees do not have the required level of performance to warrant work from home. Are our hands tied here? Okay, I might actually just take this one, and this is something that comes up in practice quite a lot. So a couple of things that I would say about this. So first of all, where there is an absence due to an illness, where there's a medical cert, and where that medical cert appears to suggest that working from home, at least on a temporary basis, will facilitate a recovery and a return to work. I think that entire exercise needs to be regarded through the lens of, providing reasonable adjustments, providing reasonable accommodation to somebody in order to facilitate the recovery and the return to work. In other words, it can't be looked at solely through the lens of a request for remote work, which is completely unrelated to the reason why the employee is looking for that remote work. So in other words, this is a situation where you're really managing an absence. We talked about the Beacon Group case earlier. We talked about the Westwood tests. And so in terms of managing this, again, what you're doing is you're having the employee attend before the company doctor. The company doctor should be, briefed in a very neutral, sort of information-focused fashion, explaining the length of the absence, explaining the demands of the role and how the role actually works. And that could include, look, there's a requirement for the role to be on site. You get the guidance of the company doctor. You sit down with the employee and you discuss it. But I think you'd have to be very careful about saying to an employee, look, you absolutely can't work from home. Our policy doesn't allow that in circumstances where the request is coming off the back of a medical cert. I mean, a related question that we would often get asked is, well, what happens if there's a dispute between the doctors? How do we resolve that dispute? It's not easy to answer that. I mean, certainly if it's a dispute on the medical advice, then likely you're going to get likely more specialist medical advice, because whether the medical advice is correct or not correct is not a matter that any of us who are not medically qualified can determine. So where there is a dispute or a conflict between the medical evidence, it is very important to try to resolve that using medical guidance before you take any steps that would be detrimental to the employee. Okay, Ciara, I have an immigration question here, which I might ask you to deal with, please. It is, can an employee bring their employment permit to a new employer?
It's a really good question, and it comes up for us quite a bit in practice. And I suppose historically, the position was that the employment permit was linked to the employer. So when an employment permit was granted to an employee, it was granted in respect of a specific role with a particular employer. and it couldn't travel with the employee. So if an employee was changing roles, say within 6 months of being granted an employment permit, they wouldn't be able to take the permit with them. They'd be back at square one, submitting an employment permit application, waiting the initial 12-week period before their start date. So it was previously was quite difficult in that respect. Under the new act, there is scope for an employee to bring an employment permit with them, so to move it to a new employer. Now, we're still in the early days. The act was only commenced 6-7 weeks ago, so we're still very much in the early stages. But I think it is worth noting that particular advice will need to be taken before an employee is permitted to start on the basis of a previous employment permit, because there could be changes in the role. So often what we see when we are working on an employment permit application, particularly if it's a critical skills employment permit, there'll be very precise roles which are eligible for that type of permit. And if an employee is moving to a new role, their previous role and their new role might not match up exactly. So there may be some differences, and there may be, it may be the case that the new role isn't falling squarely within the scope of a role that's on the critical skills list. So we're moving. I think we've moved in a good direction with the new act. There's definitely going to be some scope to do that, and there are time limits involved as well. So an employee will need to have completed at least 9 months on an employment permit before they do any moving. But I think it's something that'll need to be examined on a case-by-case basis. But there is a little bit more flex on foot of the new act. So I think that will be helpful in practice going forward, definitely.
Okay, good stuff. Good news for both employers and employees.
Exactly.
In that respect. Okay. There is actually there's a couple of questions on redundancy. I might deal with one, and I might give one out to the team to deal with. So this question is, what happens if someone discloses they are pregnant as part of a redundancy consultation process? Can we continue with the process? So again, yeah, this is something that comes up in practice quite a bit. Potentially kind of unhelpfully, the answer is it depends. So the basic point of departure is that you cannot issue a notice of termination or have a notice of termination take effect during maternity leave. Okay. So if someone has notified to their employer that they are pregnant and they're going through a redundancy consultation process, that per se is not something which is, continuing with the redundancy consultation process is not per se something that is unlawful. As listeners will know, there is extensive protection against discrimination on the grounds of pregnancy and maternity. So that is a subset of gender discrimination, and it is entirely prohibited. So what I would say is, if the employee is going to be in some way disadvantaged in terms of, for example, applying for suitable alternative employment, or having an extension of the consultation period, which I think, Ciara, you spoke about when you were running through the cases on redundancy, then that potentially is straying into the territory of putting that employee at a disadvantage. And you need to be careful about that. And that disadvantage would be very closely connected to the pregnancy and or maternity. So I think what I would say in response to this question is, there's no immediate bar on continuing with the redundancy consultation process, but you would definitely need to be very careful, potentially take legal advice on this, but just make sure that the employee has a full opportunity to engage in the consultation, that they're not going to be disadvantaged in any way by reason of their impending maternity leave. Okay, there's another question on redundancy, Ciara. I might ask you to deal with it. Any tips for best practice for redundancy selection during large layoffs or redundancies?
Yeah, an interesting question. And again, I think, unfortunately, we've seen this come up over the past few months where there are, a kind of a large restructuring happening across an organization, and identifying particular employees within a group of, say if you have a team of 10 employees in very similar roles and you need to reduce to 5 or to 6, what is the selection criteria that you use? And I suppose we touched on it in earlier in the Pluralsight case. So the key piece is really ensuring that the selection criteria is fair, it's objective, it's not subjective. So it goes back to the principle of the redundancy being based on the role, not the person. So it very much needs to be focused on objective and clear criteria. What is objective? I suppose it will very much depend on each scenario. Something we see used quite often, kind of the age-old selection criteria of last in, first out is often applied, in terms of, you know, retaining the kind of the talent within the business and someone who has longevity of service within the business. Generally, we see clients using a matrix, so there'll be a selection matrix applied, and you know, certain criteria will be weighted so that there may be a mixture of, you know, focusing on technical skills and educational background, and applying different weighting to each of those. I think that's the one of the key pieces anyway for employers starting off, is keeping the objective and fair criteria in mind. It can be tricky for clients. I suppose we see this coming up as well, where there's a global restructuring going on and a client wants to apply the same selection criteria at a global level. But unfortunately, from an Irish perspective, we do need to delve into the detail and the criteria being used, because they do have to be fair and objective. You don't want to have things like disciplinary processes or PIPs, you know, running in the background, contaminating the selection criteria. So it's very important to keep it fair, keep it objective, and I suppose giving employees an opportunity to comment on the criteria is also very important. So at an early stage, providing the criteria to employees, giving them a couple of days to give feedback, give comments. It doesn't necessarily mean that the criteria has to be totally taken apart and changed, but allowing the employee to feed into the criteria that's going to be used, I think, is another, you know, key piece of advice for clients to keep in mind.
Yeah, no, absolutely. And that's a very good point about the global restructures and just, I suppose, the local, like, customizing it where necessary from an Irish employment law perspective. So look, I think we will close on that basis. I'd just like to say a really warm thank you to Ciara and Chris for their really great work in helping to put this 2024 case law and legislative review together. I'd like to thank the listeners for joining us. As always, we have to say this is a case law review and it does not constitute legal advice. If you have any specific questions, please do seek tailored legal advice. But we really hope that this has been helpful. So thank you very much for joining us.